This is the Know Your Law series by Barefootlaw, a non-profit organization which uses digital innovation and technology to provide free legal information and guidance for all. For more information, visit www.barefootlaw.org.
Welcome back. We're still on this topic of inheritance and relationships. Our next question is, what can be done to an heir where both parents are deceased but he never takes responsibility to do his part and just watches as things get from bad to worse?
Thank you for that question. In that kind of circumstance, you need to examine whether, first of all, any letters of administration have been gotten in respect to the estate, or any letters of probate have been gotten in respect to the estate. Reason being that once a person is appointed an heir, he doesn't take on automatic responsibilities and powers to administer or manage an estate. And as such, in the event that is not forthcoming, to be a responsible heir and to take on the responsibilities of convening other family members and managing an estate, decisions can be made. I will start with a situation where neither letters of administration nor letters of probate have been gotten by the heir or the family. In that situation, the family can summon a meeting to appoint a group of individuals to support the heir in fulfilling his responsibilities as well as in catering to managing an estate. The family can appoint at least 2 more people so that 3 people apply for the letters of administration before a court of law for this grant to manage the responsibilities and the affairs alongside with an heir. In the second circumstance, where there's an heir who is not fulfilling his duties and responsibilities, but letters of administration have been gotten or letters of probate have been gotten in respect to that estate, the family can sit once again and table their grievances with this person who is an heir but has not fulfilled responsibilities, and suggest other individuals or family members to take on the responsibility of managing the estate with an heir. How they do this is, first of all, by seeking to revoke a process which is undertaken before a court of law that granted end of the letters of administration or probate, cancelling the previous grant, and then seeking to reappoint the heir with at least 2 individuals to assist in the process of managing the estate of a deceased person. So the final consequence of cancelling or revoking the grant is to have new individuals appointed under new grant of letters of administration or letters of probate to manage the estate where the heir is failing to fulfill his role.
What happens to the property that I owned together with my first deceased wife?
So property under a marriage ordinarily is said to be jointly owned unless the circumstances and the situation is interpreted differently or has a different legal interpretation by way of ownership. So you will need to look at exactly what the nature of property available is. If the property we're looking at is owning a home, a matrimonial home with your deceased wife, it would mean that you as the husband will take ownership of that matrimonial home by virtue of surviving your deceased wife. In the event this property is commercial, a commercial property, let's say a mall, a building with shops, or a distinguished commercial property somewhere, accruing profit or money by the month, this property will be taken to be co-owned with you and your deceased wife or deceased ex-wife. And as such, you will be entitled to a portion of this property, but the children and beneficiaries or estate of your wife, of your deceased wife, shall be entitled to take ownership or to inherit a benefit from this co-owned property being a commercial property. So you need to distinguish the nature of property from whether it's matrimonial or commercial to determine what can be legally inherited or what you can legally share as an inheritance with the estate of your deceased wife.
Should we both make wills if we are married?
If you're married, the encouragement is to always have a meeting of minds and have a joint understanding of your affairs. And as such, the law provides for writing what they call a mutual will. A will that takes on the representation of your wishes as a married couple, being husband and wife. So you also specify all properties owned by you as a couple, and you specify what happens to managing, distributing, and owning this property in the event of your death. However, in the event that you're not comfortable, the law also gives you an opportunity to freely write individual wills as a husband and to freely write an individual will as a wife. Coming from the fact that both of you have a legal entitlement to own and possess property, jointly or individually. In the event that you are not comfortable writing a mutual will, you may write individual wills specifying the nature of your properties, the individuals you may want to take over inheritance of a property and manage the property individually. And you may also appoint distinguished executors. As I mentioned when we were introducing this edition, an executor is an individual who is appointed by a deceased person to implement the wishes specified under a will. So that can also be a distinction from the distinct wills by a husband having his own executor under a will, and a wife having their own executor under their own will.
What advice do you give to a family of adults whose parents are deceased but there is no harmony? Kindly advise on dividing property equally so that those who want peace can put their plans together.
In the circumstances of conflicting interests of adults, we usually encourage individuals in that kind of situation to convene a meeting with elders involved, elders of a family involved, to guide on processes of what may be adopted as an understanding, appointing a few individuals to pursue getting letters of probate in the event a deceased left a will behind, or letters of administration in the event there is no will left behind by a deceased person. Now, amongst the individuals appointed, we encourage that all various people with interests identify one person to constitute at least 3 people who can represent the wishes of each part of the family, which then provides an opportunity for a level of understanding and distribution of property to a fair, equitable, and good understanding of everyone represented in the estate of a deceased person. In the event this family of this meeting of elders does not arrive at appointing the 3 individuals or a group of individuals because of, again, a misunderstanding, we suggest that they use the Office of the Administrator General to intervene in that kind of family conflict and challenge regarding succession. First of all, to guide on what may be adopted. Secondly, where all has failed, to seek that the Administrator General assist in administering over that estate for the benefit of harmony and fair distribution and management of that estate.
What happens when a man loses his wife with whom he has children, some quite young, and goes on to marry another woman legally? what are the rights and obligations of the new wife as well as the children from different mothers?
First of all, we need to understand that this lady left behind by a deceased husband is legally married, and first of all is entitled to inheritance as a legally married wife to the deceased. Secondly, we need to emphasize that having been married and in a home, she carries a responsibility of being able to take care of all children, whether biologically produced or born by her, as well as the children of any other previous spouses to the deceased husband. So she is entitled to acquire an inheritance in respect to her position as a wife of a deceased. She's also responsible for taking care of the children as they are, both hers and those of the previous spouses, and also ensure that the children of the other spouses that may not be hers also benefit in an estate, because the law provides that all children are entitled to a share of inheritance from their deceased parents.
Thank you so much for that. If you have any questions or something you want clarity on, leave a comment in the section below. And if you want to get in touch with our legal team, remember there are links to the different channels you can use to do that.